Welcome to this Executive Knowledge lecture on Topic 5, Paper 1 of the SFC licensing exams. This topic covers business conduct and client relations and looks at how intermediaries should behave with clients and the outside world. As ever, I'll emphasize the important points to help you understand the core material that you need to sit the exam. And again, a copy of the study notes that you see on the screen can be downloaded from the Executive Knowledge website under the Paper 1 resources. And once again, I strongly recommend that you supplement this learning with question practice that we provide with over 500 practice questions on the platform Examinator.online. So what do we have in topic 5? Essentially, we have 6 codes of conduct. Now, remember, codes of conduct are not legislation. So if you breach a code of conduct, an SFC code of conduct, you're not breaking the law, but the SFC may look upon it negatively, and the worst, they can revoke your license and possibly fine you. Let's look at the introduction. As I've already alluded, topic 5 looks at external relationships, particularly with clients, and topic 6, when we get there, looks at internal operations and codes. And we've said there that we're going to cover 5 codes. We're actually covering 6. So we've got the Code of Conduct, Fund Manager Code of Conduct, Corporate Finance Advisor Code of Conduct for persons providing credit rating agencies, and the Code on Open-Ended Fund Companies. There is a 6th, the Code of Conduct for Share Registrars, but we don't really see that as a sort of a mainstream code. Nevertheless, it's in the material and we will look at it. Okay. Remember from topic 3, well, this is what I said, a failure to comply with the Code of Conduct, not a legal offence, and I've already considered that. Now, how do I study for topic 5? The most questions are going to come from the Code of Conduct itself. We refer to that as the Mother Code of Conduct. And its full title, you will see there under para 2, Code of Conduct for persons licensed by or registered with the Securities and Futures Commission. We sometimes consider that the Mother Code. The largest number of questions are going to come from that code. However, there will be 1 or 2 questions on the Fund Manager Code of Conduct, and there can be 1 question on the Corporate Finance Advisor Code of Conduct. So you don't have as much material for Fund Manager Code and the Corporate Finance Advisor Code, so you get a better return on your time invested because it's not as much material, far more material than the main Code of Conduct. So that's just a point I want to highlight. Code of Conduct, persons providing credit rating services, it has been examined, but not every exam, so it's a bit of a hit and miss. Code on Open-Ended Fund Companies, yes, recently they have been setting 1 question on this, so I would be aware of it. Code of Conduct for Share Registrars, very unlikely that it will be examined. So we start off looking at the Code of Conduct by recognizing there are 9 general principles that we need to be aware of, and there they are, from honesty and fairness all the way through to responsibility of senior management. And I'm going to be covering these codes and picking out the points that you really should be aware of from the point of view of the exam. Now we start with general principle 1, honesty and fairness, and not surprisingly, a licensed registered person should act honestly, fairly, best interests of clients and integrity of the client. And they give us more specific conditions as listed there. General principle 2, diligence. Licensed registered person should act with due skill, care, diligence, best interests of the clients, integrity of the market. And again, we are given some practical examples which can come up in the exam. You're expected to execute client orders promptly and execute them on the best available terms, which they refer to as best execution. Allocation of orders should be prompt and fair to the clients, and advice should be given with due skill, care, and diligence. Now, telephone orders, that really is sort of records of trading. Well, the telephone orders should be recorded, and the recordings should be kept for at least 6 months. And the next bullet point I am going to highlight, because an examiner recently saw fit to examine it. Use of mobile phones for taking client orders strongly discouraged. Should be prohibited on the trading floor, trading room, normal place of business. Now, the code, it's not illegal, but the code is suggesting that they should be prohibited. Elsewhere, time of order receipt and details for order taken by mobile phone should be recorded immediately by a call to the office telephone recording system. And the question that was set was that you take a call on a mobile phone outside the office, what should you do next? And the answer was you should record immediately the order by calling into the office telephone system. General principle 3, capabilities. And this is really to do with capabilities of the intermediary. You should have the required systems and procedures, and that's really dealt with topic 6. And there's a few more that are listed at the bottom of page 5.3. General principle 4, the information you should have about clients. Know your client, KYC, due diligence, and all that information. So there is a significant amount of material here. The point behind this is nowadays, with money laundering and illegal positions, you should know who your client is, the true and full identity. And if it's a corporate, you should know who the ultimate beneficiaries are of transactions. And we've given the detail that has been listed there. Also, in the last year, and you can see effective, I'm looking at online platforms. You can see effective from 6th April 2019, the SFC issued guidelines on online distribution and advisory platforms. And the guidelines have 5 main parts, and we've listed them there for you. Outside chance if that is examined, but be aware it exists. Client agreements, yes, you should have a written client agreement before you provide a service to clients, and the details of client agreements are listed for you. Also, client agreement should contain the appropriate risk disclosure statements, and we list the potential risks that should be referred to in a client agreement if applicable. Discretionary accounts, top of 5.6. If you are operating an account using your own discretion and the client has authorized it, then there should be an approval by the client. And the Code of Conduct says imposes the following on the establishment and operation of discretionary accounts. And as I said, the client should give authority in writing. General principle 5, information for clients. So we've looked at the information under general principle 4 of the information you should get from clients. This is the information you should give to clients. And it really is to encourage transparency and give details of your business. And second bullet point there, licensed registered person must disclose to its clients any benefits it's directly or indirectly receives from a product issuer for distributing an investment product. And it goes on to give a little bit more detail on that. Principle 6, conflicts of interest. The opening position is you should try and avoid conflicts of interest. If you cannot avoid conflicts of interest, then you should inform the client of the conflict. Handling of client orders should be handled fairly in the order in which they are received, and we have seen that examined. Client orders should have priority over orders of the house account and employees. Well, just generally, clients have priority in orders, in allocation, in doing business. Withdrawal of business, actual or potential conflicts, details are given. Rebate, soft dollar connected transactions. Be aware of the concept of soft dollars. This is where brokers can reward investors or fund managers for directing business to them. The main requirement to provide these soft dollars in the form of services is that, and this is the third last bullet point, page 5.7, those goods or services provided by the broker must be a demonstrable benefit to the client. That's an overriding consideration. And there you have the goods and services permitted by the SFC, page 5.8, and the goods and services not permitted. Very straightforward. Be aware of those points. And then last few points on the receipt of money or cash rebates. Is it allowed? Yes, but must be full disclosure to the client. Continuing with conflicts of interest, there is material on what analysts can and cannot do. This is not difficult. A lot of it's common sense. I would read through and be aware of it. Moving on to page 5.10, General Principle 7, compliance. So we're now being reminded that although we've been covering the legislation, the codes and the guidelines, we will move on to guidelines. You've got to comply with all this. So got to comply with primary subsidiary legislation, the rules, regulations, codes, rules of exchange and clearinghouses, and requirement of any other regulatory authorities. We've listed their obligation under the Financial Dispute Resolution Scheme. I wouldn't worry about that. Came in 2012, never seen it examined. Employee dealings, on the other hand, totally different. Yes, that material regularly examined, so be aware of the need for an intermediary to have a policy on employee dealings, and we've listed what the policy should cover. Complaints, client complaints, the major point is client complaints should be dealt with promptly. The word prompt, if it's in the answer, that's what you go for. Responsibilities for active employees, not surprisingly, intermediaries or a licensed corporation or registered institution is responsible for the acts of the employees. And then we list a number of notifications that must be made to the SFC. Now, these are fairly important. In the real world, especially the large institutions, if they come across any of these matters, they will inform, they will notify the SFC immediately. And it's when they discover material breaches or suspected material breaches of any law, regulation, or code, insolvency situations, disciplinary action taken against it, material problems with business system and equipment, and suspected material breaches of market misconduct provisions. Yep, in all of those cases, you should notify the SFC as soon as possible. General Principle 8 on client assets. Well, we've got specific rules that we covered in topic 4 on client securities and client money. This principle is a lot older than the rules that we covered, so it's a lot more general, and it tells us that intermediaries should ensure client assets are promptly and properly accounted for. Client assets are adequately safeguarded, as I said, the wording very general. And as I've just mentioned, we do have specific subsidiary legislation covering client securities rules and client money rules. General Principle 9, responsibility of senior management. Now, this has been expanded in the recent few years. Right at the top, we're told that senior management should bear primary responsibility for ensuring appropriate standards of conduct, etc., in the firm, and senior management should understand the nature of the business, internal control systems, procedures, risk management policies, and the extent of their authority and responsibilities. Now, who are the senior management? And this was fairly vague previously, but now SFC has made it very specific. And here's the list. All directors, including shadow directors that we covered in topic 2, responsible officers that we covered in topic 4, and any individual who is manager in charge for one or more of the following core functions. Now, there's 8 categories of manager in charge. Now, we came across this in topic 4, and that is that those that are involved in the first 2, overall management oversight in key business lines, must be responsible officers, therefore must be licensed. But the other 6, from operational control and review down to anti-money laundering, counter-terrorist financing, don't need to be licensed, but because they're not necessarily involved in a regulated activity. But the point of this is now such managers in charge do have responsibility, being senior management, and must follow General Principle 9. So the points at the bottom, as I've said, individual does not need to be licensed to be identified as a manager in charge. But once you have been identified, any changes to your roles must be identified to the SFC. You must be fit and proper to carry out your duties. And it's the SFC that will use its discretion to determine if the manager in charge is fit and proper. And the manager in charge's past conduct, including compliance with SFC codes and guidelines, even though they weren't previously licensed, will be taken into account. And I have seen that point examined. So please be aware of the concept of managers in charge.